One of the first questions I get from clients is when they come in for a will, they ask, well, what will happen if a person dies without a will? Well, the state legislature has a will for you, and it does name certain beneficiaries, typically the next of kin. But that quite often is not what the person wants or should have. The state will, called intestacy, does not include naming a personal representative or guardians or trustees or any devises a person might want to make to children or relatives. There are many things a will can do that are quite beneficial to a client that the state statute called intestacy does not do for a person.
Well, I think it's a good idea to have an attorney do your will so that your documents are taken care of the way you want. I've seen clients come to me who've done their will themselves, they've done their will on their internet, and they don't understand what they're doing. And when you read their documents, it makes no sense at all. When they pass away, they're going to have a problem. That's when you get into will contest and you get into other issues related to the interpretation of the will. By having an attorney do it, you know that your document is going to be done right the first time. If there are changes in the law, you're going to be contacted by your attorney to see if there's changes that need to be made to your will so that you know when you pass away, your documents are going to do what you want. An estate plan is the mechanism by which your assets transfer at the time of your death. There's a variety of ways to do that. A lot of people do what I call inadvertent estate planning. It's the way they own assets, as joint tenants, payable on death, transfer on death, or sometimes by beneficiary designation with life insurance, 401ks. The other way that estate planning happens is when people don't do anything. And what you end up with is what's called intestate succession. And that's a state statute for how your assets are going to transfer. What most people think of when they talk about estate planning is seeing a lawyer to do a will or do a trust or do some other document that sets forth how their assets are going to transfer at the time of their death, who is going to be in charge of their estate, and when those assets are going to transfer. And that's really the main reason that you do an estate plan, is so that you control how that happens when you pass away. Probate's the process by which your assets transfer at the time of your death through the court system. If you think about it this way, if you're a single individual, you own a house, a car, a bank account, and you pass away, who has the right to sign your name to transfer any of those assets? The simple answer is no one does. That's what the probate process is for, is to put someone in charge of your estate as your personal representative so they have legal authority to gather your assets, pay your bills, and then make distribution of your estate to the people that you want. Probate doesn't have to be a long process. In Minnesota, the minimum amount of time that a probate has to be open is 4 months. Many of the probates that we do are what are known as informal probates, meaning we never make any court appearances. We do them by mail. Now, having said that, probates can take a long time if your family is feuding or if you're having other issues with families. The court does not dictate how long the probate will be open. Your family will dictate how long the probate will be open.
Some clients have an estate they don't want to go entirely to their young children. When a person dies and there are only minor beneficiaries, the minors will receive the entire estate. Quite often, parents don't want young children or even teenagers or young adults to have an entire estate. So one device we can put into a will or a trust is a contingent trust, and that allows the parent to name a trustee to receive assets on behalf of a younger person, and then they can create a plan for education or some time distribution to this younger person. So if the parents decide that's something they want, we create the language and then place this, the assets into a contingent trust run by a trustee chosen by the parents and distributed under their plan.
Normally when we set up an estate plan, we do a will or a trust for people, but there's also 2 other documents that we recommend that all of our clients have. One is a power of attorney and the other is a health care directive. A power of attorney is for the purpose of appointing somebody to handle your financial affairs for you while you're alive. Generally it's used if someone's incapacitated or unable to handle their affairs. By having a power of attorney, it avoids us going to court for a proceeding called a guardianship and conservatorship. So it can save our clients a lot of money. The other document that we recommend people have is a health care directive. A health care directive does 2 things for our clients. First, it allows you to appoint someone to make medical decisions for you if you're not capable or competent to make your own decisions. The other thing that it does is it tells your family and your physicians what kind of care you would like in the event that you're either in a terminal condition or a long-term vegetative state and you no longer can communicate.
When I meet with a client, the issues of joint tenancy, pay on death, and transfer on death come up. A lot of clients don't know what they are, what the differences are. Joint tenancy deals typically with an account or property owned by two people at the same time, with the survivor taking the entire title to an asset upon the death of the first decedent. A pay on death is typically with a bank and a bank account, so that the individual owns an account in his or her own name, but upon death the account transfers directly to a survivor. A transfer on death is similar. It's typically dealing with a stock account. And so the legislature has allowed transfer on death accounts so that now stock accounts owned individually by one person can pass to beneficiaries upon the death of that person.
Barna, Guzy Steffen has been helping clients solve their business and personal legal problems effectively and efficiently since 1938. Barna, Guzy Steffen, large enough to serve you, small enough to know you.